The Supreme Court has heard arguments on whether the Tax Injunction Act applies for Obamacare. ObamaCareWatcher.org's John Vinci explains.
The Tax Injunction Act is actually a very old law from 1867. Essentially, what it does is it says that you as a taxpayer have to pay your tax before you dispute that tax in court. And both sides, both the states and the federal government, are both saying that this is not a tax under the Tax Injunction Act. In fact, the court actually, because both sides agree that this is not a tax for the Tax Injunction Act, they actually had to hire an attorney.
The court's separate attorney, Robert Long, is arguing that Obamacare has characteristics of a tax.
Essentially, what Robert Long is arguing is that the individual mandate, while the Congress has not called it a tax, has all the indicia or all the characteristics of a tax, and thus the Tax Injunction Act would prohibit the Supreme Court from hearing the case until the parties are taxed.
What does it mean if the Tax Injunction Act applies?
It means that we won't see this case until 2015, at least on April 15th of 2015, when people who violate the individual mandate will have to pay a tax.
To read more about and speak out on Obamacare, visit ObamaCareWatcher.org.